First case is in re LP and JE. Looks like we only have the appellant arguing today. You'll have 15 minutes to present your argument. If you, well, you're not reserving time, so it'll just be a straight 15 minutes. You are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the name of children, minors, or victims during your argument. You can refer them by initials or terms like the child. You have read your brief and are prepared to proceed when you are.
Thank you, Judge Landinger. Your Honors, may it please the Court, Andrew Harris on behalf of the appellant's mother in this case, mother to both of the subject children, JD and LP. We've raised 4 assignments of error in this case. I'm going to spend the bulk of my time talking about the middle 2, which, under different standards, challenge the correctness of the trial court's dependency adjudication. This Court has held time and time over that a parent's substance use in the abstract does not give rise to dependency on the part of that parent's children. Here, the agency admitted at adjudication that it could not prove the central factual allegation in its complaint, specifically that there was a photograph depicting mother engaging in illicit drug use with JD in her lap. The agency admitted that it couldn't demonstrate that photograph was real, did not attempt to offer it into evidence. The magistrate sitting as fact finder, as well as the trial court agreeing, said that whatever the photo could be considered for, it couldn't be considered for substantive proof of its contents. Despite that, the trial court did find subsection C dependency in this case, 2151.04, which requires proof of the child's condition or environment being such that the state is warranted in assuming the child's guardianship. In making that determination, the trial court relied on mother's generalized self-reported history of THC and methamphetamine use, mother's, again, self-reported mental health diagnoses, and a general history of domestic violence with LP's father. I would submit that none of those supported dependency adjudication on these facts. As it relates to drug use, again, there are general statements that mother made to the caseworker, and the caseworker testified to that she has a history of using marijuana as well as methamphetamine, and 2 statements of admissions to post-removal use of methamphetamine. In fact, in mom's telling, and neither the magistrate nor the trial court seemed to discredit this explanation, the reason she used following removal was the fact of removal itself.
So what was the time gap for that? Was the removal and then her admission, was there some kind of gap? She
Sure.
had the child and dropped off the child? And...
Correct. So what I would say is the agency, I think, tried to elicit testimony from the caseworker that perhaps one of these instances of use happened after mom learned of removal but before she turned them over. But I don't think the record clearly or convincingly demonstrates that at all. So just looking at the transcripts, this is 54 to 55. So she learned of removal on the 23rd of July, and then wasn't available to turn them over, and then turned them over later that day after the agency was able to establish contact.
And was there an oral swab that day?
There was.
And that was positive?
Well,
the distinction was positive. Is that fair to say, or you're going to tell me that it's not necessary? So go ahead.
So there's no evidence that the day of the removal swab was not entered into evidence. It wasn't offered into evidence. No, mom does admit.
Was the only testimony that the caseworker said, I did a swab and it was positive?
Actually what the testimony reflects is the agency received results of that oral swab taken on July 23rd. The caseworker says yes. And the follow-up question is, did you ever discuss the results with mother? And she said, yes, I did on July 26th. Now, she doesn't specifically say that it was positive, but mother does go on to admit to the day of removal, admitting to use after learning.
Okay, so when was that swab taken? Was it when she relinquished her children?
So yes, and to be clear, the conversation that happened between the caseworker and the mother was not on the 23rd. It was 3 days later, on July 26th.
I understand, but she had the children, she did the swab, and it was tested positive all at the same time.
So I don't think the record actually makes it very clear that that swap happened, at the time she surrendered the children or not. What I would say is, so when the agency sort of tried to draw that out, well, necessarily the children were in her care. What the caseworker said is she did not say that they were ever not in her custody at that point. So whether or not that's very convincing proof, I think it's worth emphasizing that on direct examination or on cross-examination, when the caseworker is more pointedly asked, so this is pages 63 to 64 of the transcript, were there any concerns about the children? Answer, other than the concerns for exposure to drug abuse, no. Question, other than the photo, is there any other time you're alleging that mother was doing drugs in front of the children? The answer was not specifically no. Again, this court has held that drug use, in the general sense, is not a conditional or environmental impact within the meaning of subsection C of the dependency definition. Here there is scant testimony or evidence about the condition or environment of the children at all. There's some question elicited again on cross-examination of the agency caseworker that, were there any concerns about the home? The answer was not the home condition, no. To the extent there was any evidence of this, the indications are that the children were appropriately housed, appropriately clothed, appropriately fed, meeting developmental milestones. But there's very little about the children in evidence at all in this case. And I think, the focus on mother's punitively bad behaviors is telling in that respect. So, drug use aside, the agency in its brief has cited mother's mental health concerns. So there is a single line of testimony in the transcript in which the caseworker relates that mother told her that she had diagnoses for ADHD, PTSD, and anxiety. I think principally the agency in its brief relies on the JC case from this court, essentially to imply that a parent's mental health is in and of itself tantamount to being an environmental or conditional impact, and I just don't think that's a correct reading of JC. Just to say,
Is there any evidence presented about her having treatment for it, or that she needed treatment, or?
so there's a statement that she intended to seek treatment, and
No psychologist involved saying she should be doing something?
so certainly nothing was presented indicating that her mental health concerns had these impacts upon her child rearing, and she would benefit from either therapy or classes or anything like that. That's just not an evidence here. Again, in JC, the facts of that case were that mother doused things in bleach in the apartment, threw pentagrams in the yard, ran with her children to a police station. There's just, again, factually nothing like that in this case. Which leaves us with, again, mother's statement that she has a history of domestic violence with LP's father. The children, just to the record, to be clear on the record, do not have the same father. LP is the older of the two children. And while there are some allegations specifically talking about convictions in what is the Second Amendment complaint filed in October, there's nothing in evidence describing what that history of domestic violence is, other than, again, the agency's testimony that mom told her there is a history of domestic violence. And that's one line of testimony in the transcript. The balance of the testimony is that, again, LP's father is a non-custodial parent. They don't live together. Visits between LP and her father, the testimony reflects that they happen in the community, so there's no live concern that there is some conditional or environmental impact on LP. To say nothing of JD, who is not, who does not have the same father. So I would submit that there's just really not enough there demonstrating that there's a kind of conditional or environmental impact that you need to see in order to demonstrate the tendency. So I see that I have about 5.5 minutes left. If there are any questions about those back as questions may arise. Just briefly, I want to touch on our fourth assignment of error, which deals with the reasonable efforts that the agency testified to. So under Revised Code 2151.419A, the agency has the burden of demonstrating that it undertook reasonable efforts either to prevent a removal, to end an ongoing removal, as procedurally, as posturally as appropriate at the time of the stage of proceedings. So there are a couple of reasons here why I think the agency did not meet its burden to demonstrate that there are reasonable efforts. And the first is that this hearing arises or this appeal arises principally from adjudication. And at the adjudication hearing, the agency exclusively presented testimony from its intake caseworker. Her testimony, Ms. Windsor's testimony, was that her involvement in the case stopped August 1st of 2024. That is when she had a conversation with Mom about the results of the second drug screen. That is the one that is in evidence. And there were no evidence of what efforts, if any, the agency took to eliminate continued removal or to make it possible for the children to return safely home from, again, August 1 until October 11th.
Did Mother challenge the agency's efforts to prevent a continued removal?
So she challenged reasonable efforts in her objections to the magistrate's decision. What the scope of that was, whether she articulated it exactly as I did, I would have to check the transcript. I would have to check, the text of the objection that she filed. But what she certainly argued was more substantively with respect to the efforts the agency did take at the time of removal were not reasonable within the meaning of the statute. Specifically, that there was no testimony. Well, there's testimony about things the agency did as part of its duty to provide child protective services. There's no testimony that the agency weighed the relative risks and benefits of removal. In fact, the agency caseworker admitted that removal was likely traumatic for these children. The agency didn't take any investigative efforts to demonstrate that the photo on which it premised removal was real. So both the shelter care transcript, which does appear, which is lodged with this court, as well as the adjudication hearing, there's testimony to the effect that they didn't reach out to the person who purportedly posted this photo, and there's a name associated with it, and that person was never contacted by the agency, and was never, or there were no other independent efforts to verify that this photo is in fact what the agency alleged it is in front of them. Given that I have about 2 minutes of time, I'll just briefly address the evidentiary issue that we raised in our first assignment of error. So the result of that second drug screen, this is the one that was swabbed July 29th, about a week following removal, was admitted by the trial court under the business records exception to hearsay rule. And so, among other things, 803 requires that a business record has to stem from a source who has personal knowledge of the acts, events, or conditions. Now, that doesn't necessarily mean that the records custodian themselves have to have personal knowledge of the acts, but they do have to stem from a source who has personal knowledge of the acts, events, or conditions recorded therein. And here, the record custodian that the agency testified, or brought to authenticate these records, squarely testified that he would need to review the internal chain of custody documentation that was associated with the report they admitted into evidence in order to verify that, and he did not have that available at the time of his testimony. So we cited an 8th District case, that's the Powell decision, 2019, Ohio 4345, that specifically says, well, documents like these, like the ones admitted in this case, are admissible when you have chain of custody documentation included. And here, by contrast, that documentation, which would demonstrate that these are what they purport to be, just it isn't there. And so for that reason, I would submit that it was error to admit the forensic fluid report.
So counsel, on that point, was it included in PFC's pretrial statement that they were going to be admitting that?
I don't know, but my recollection is, so the agency has said that we waived that argument in its own brief. We've
Right.
raised objections to it. I think that's incorrect because in our pretrial statement we do have language objecting to that. That's quoted in our reply brief. The specific portion of the record where we preserved that objection in our pretrial statement.
Was it that broad objection?
It was. So there's a specific objection to the photograph, but certainly there is a general objection to any and all exhibits photographs. And even if this court was to find that generalized objection insufficient, I think the local rule captures the need to object to the authenticity of an exhibit rather than its admissibility. The express purpose of that under the local rule is to obviate the need to call records custodians, and here Mr. Levitas was called as a records custodian. So I don't. So even if there is a technical failure under the local rules to make a specific objection to the forensic fluids report, there's no prejudice to the agency because of it. And I see that I'm out of time, so if there are further questions,
Thank you.
I would ask this court to reverse as we've requested in our. Thank you.
Thank you for your presentation. The court will take this matter under advisement and issue a ruling and report. The clerk of court can mail you a copy of the decision on the day of release, and also the opinion is posted on the Ohio